Introduction by members. Madam Clerk.
Introduction of bills. Orders of the day.
Acting Government House Leader.
Thank you, Mr. Speaker. In Section A, I call Committee of the Supply Estimates for the Ministry of Tourism, Arts, Sports and Culture, and here in the Chamber Committee of the Whole for Bill 4, Business Practices and Consumer Protection Amendment Act 2025.
Committee chairs.
Members will be in a short recess before we undertake discussions. I'd like to call the committee to order on Bill 4, 2025 Business Practices and Consumer Protection Amendment Act, 2025. On Section 1. Shall Clause 1 pass? Member from Richmond Queensborough.
Thank you, Madam Chair. I would like to ask whether I'd like to learn, I'd like the Attorney General to walk us through the process that was followed in terms of consultation for review of this particular bill with which stakeholders. So if we could have information on what was the process that was followed in terms of consultation in regards to this bill.
Attorney General.
Thank you. Before I begin, I'd like just to thank the team that's with me today. We have Jess Gunnarsson and Darren Thompson. I just want to appreciate their work and their guidance through today. So there's been years of work on the changes that you see before you in this bill, starting in 2019 with a significant and expansive public consultation that was about strengthening protections for consumers, creating borrowing rights, remedies, setting limits on total cost of borrowing, prohibiting fees and charges, restricting the use of borrowers' personal information, protecting people from wage assignment, requiring businesses that provide high-cost credit products to be licensed by Consumer Protection BC, and enabling Consumer Protection BC to enforce the acts and amendments and future regulations. A province-wide online survey was held from May 29th to July 5th, 2019, and that led to the release of a public report. The survey identified key findings, including challenges with certain contracts and billings. There were meetings with stakeholders at that point with MLA Bob Deeth throughout the many stakeholders. I have a list here that I can provide to the member instead of reading it out. And in 2022, the ministry undertook public engagement to better understand the consumer marketplace here in BC. It was focused on consumer experience in the area of purchasing and leasing products and services for businesses purchasing and leasing motor vehicles from dealers in BC and using various credit-related products and services. The public consultation received 353 responses. It's also, the work that we're doing here is also in line with other jurisdictions across Canada who have, prior to this bill, updated their business consumer protection laws, specifically due to the contracts and similar raises we're doing here.
Richmond Queensborough.
There were some consultations that were had in 2019 with particular organizations. Were those organizations revisited, Madam Chair?
Attorney General.
Thank you. So this policy has taken some time to develop, but there was further consultation in 2022, and we are in constant communications with Consumer Protection BC, that is the public authority in the marketplace that's there to regulate consumers, which is constantly giving feedback on what's happening in the marketplace.
Richmond Queensborough.
So I hear that there was some revisitation back in 2022, which is approximately 3 years ago. There has been significant changes since the last 3 years. We're dealing with U.S. tariffs at this time that are of concern to a lot of businesses here in BC. So has there been any further consultation since 2022?
Attorney General.
Thank you. So I want to acknowledge what the member said, is that there are changing times and that we are in unprecedented times, and I know the business community is certainly feeling it the most right now, along with people scared of losing their jobs. So I just wanted to talk a little bit about the design of this bill. So because of concerns that we heard from the business community about how this might be implemented, it's designed to actually be implemented by regulation. So that regulation will involve connecting with, as we do with the business community, along with other actors that are impacted on it, and understanding how we can make sure that any impacts would be minimized in the context that we're in right now in the trade war scenario. So it's designed in a way to be protecting consumers, but acknowledging that with impacts that might happen on business, there would be a way to make sure that before the implementation of coming into force by regulation, we can address any of those concerns.
Richmond Queensborough.
Just to follow up to that information, if issues will be addressed by regulation, will there be further consultation in regards to those regulations before they get formulated?
Attorney General.
Yes, in fact, we've already been connecting with certain business leaders about, and we plan on doing that, about how we implement, acknowledging that the time period has shifted, and although in this time period consumers need protection too, so we think that we are moving in line with other provinces like Alberta and Ontario that have similar protections for consumers. It also gives the time to have, given the space that we're in and the concerns that I think are very valid for people to raise about not adding things at a time when they're stressed about change, that we would 100% be reaching out and talking to the business community about how this gets implemented and when the regulations come into force.
Richmond, Queensborough.
I'm sure a lot of businesses believe in consumer protection, as do we on this side of the House. But more information here is needed in terms of how much consultation was actually done. Consultation that was from 3 years ago was a very long time, and things have really changed with the U.S. Tariff situation. I did receive a list from the Attorney General's Department in terms of a consultation list. I'd like to go through that list and see if we could have those names of those organizations that were consulted. I'd like to have those confirmed in the House today. And what I received in terms of a consultation list, these are the names that I received. Written submissions were received from Automotive Retailers Association, BC Public Interest Advocacy Council, Canadian Federation of Independent Business, Consumer Council of Canada, Council of Senior Citizens Organizations, Direct Sellers Association, Public Guardian and Trustee, Public Interest Advocacy Council of Canada, Retail Council of Canada, and also some notes were provided that former MLA Mike Starchuk also met with the Canadian Federation of Independent Business, Direct Sellers Association, and the Consumers Council of Canada, as well as Small Business BC. Another note was provided. Staff also met with the Small Business Roundtable and Vehicle Sales Authority working committees. Was there any further consultation done other than these organizations? And also, can the Attorney General confirm these were the consultations that were done?
Attorney General.
Thank you, Chair. So we cast a really wide net in 2022, which was just a wide public engagement. So anybody could have responded, whether it was a business or a person in BC. And what we received from that was 353 responses. So I don't have the specific names of the businesses or the people that responded in those 353 responses, but and I'm not sure we hold that information, but that was our broad scale consultation. In terms of specific organizations that the member confirmed, that's correct about those. So that was the compilation of consultation that we used to rely upon this bill.
Richmond, Queensborough.
I'd like to mention specific chambers of commerce, and I would like to know if they were consulted. First one is Greater Vancouver Board of Trade. Second one is BC Chamber of Commerce. Third one is Tri-Cities Chamber. Fourth one is the Richmond Chamber of Commerce. Fifth one is Restaurants Canada. And there was a sixth one, but I see that consultation was had with them, a Canadian Federation of Independent Business. But for the other five that I mentioned, can the minister please provide information whether these organizations were consulted with?
Attorney General.
Thank you, Chair. So along with the 353 responses we received in the broader consultation, I just want to note for the member that the specific associations and organizations that were deeply consulted with, so that's the Automotive Retail Association, including the Consumer Council of Canada, the Canadian Federation of Independent Businesses, Direct Sellers Association, and the Retail Council of Canada, was very specifically to get deep feedback from organizations like that would know on the front line of what was needed and how contracts show up in their industries. So that was a very deliberate group of people to help inform our team, to inform on the business impacts and how it shows up for business. So that's a usual thing for consultation, where you make sure that you're going deep with the people that have experience in it. I think with the names that the member is listed in his question, he's referring to a letter that we have all received from those specific organizations that he is mentioning, and I just wanted to say a couple things about that. One is that I have responded to that letter, and I've responded to say that I think through this debate we will be able to address the concerns raised in that letter, and I intend on meeting with those groups to talk through it, but also that the important situation that we're in right now and understanding how like I mentioned, that things get implemented through regulation, through discussions with these groups, and I plan on doing that going forward. But I think it is important to note that the organizations that we reached out to and did a deeper consultation, along with meetings that were done by Small Business BC, a Roundtable Vehicle Sales Authority, was because when you're designing a policy, you really want to know how it's going to show up for people and businesses.
Richmond Queensborough.
Respectfully, this debate does not constitute consultation. It's not a consultation process. Why I raise the concerns of those particular organizations is in that particular letter, they make a statement here. At the outset, in this letter dated March 12, 2025, as the Attorney General mentioned, that all members of the Legislative Assembly should have received this letter. In the second paragraph, it reads, "Our economy is facing significant external threats and a trade war, and businesses now more than ever, particularly small and medium-sized enterprises, are struggling." So, and why I bring up those five organizations is they serve a lot of the smaller businesses throughout BC that are the backbones of this province. And a lot of times small businesses do not have the same resources as larger enterprises to gather information of what needs to be done in terms of compliance. And so these particular organizations, the Vancouver Board of Trade, Richmond Chamber of Commerce, these organizations are usually seen as a tool by small businesses to receive information, how to comply with certain new regulations that are coming into play, how to comply with new legislation. So it is alarming and concerning when these major chambers of commerce in our province are voicing concerns, and they are saying, they have also stated in this letter, in the fourth paragraph, about in the middle, they bolded a line, and they stated here, "We ask for a pause on advancing the legislation to allow for engagement and collaboration towards better outcomes for consumers and the business environment." So this is what these chambers seem to be asking for, because they see there's been a lack of consultation. There seems to be good faith. Everybody seems to be, in favor of more consumer protection, but the concern seems to be there's lack of consultation, and that may raise unfair issues in terms of when some of these businesses are going to try to comply with this legislation, they may not totally understand it, and there might be some compliance issues. Not that it may be a purposeful non-compliance. It might be that they don't have enough information. So that's where the consultation actually comes in. So this is particularly very alarming, so that's why I'm highlighting it right now. These consultations should have been done with these chambers. There was, the Attorney General did mention that there were 353 responses to a public engagement that happened back in 2022. I would like to know whether there was any constructive feedback which suggested there needed to be some improvements made, there needed to be some of the provisions that were canvassed, maybe they could be replaced with others. Was there any type of discussion in those replies in regards to those 353 responses that the government received? Can the Attorney General tell us a little bit more about those 353 responses?
Attorney General.
Thanks. I thank the member for the question. I think we are all, I think we're all concerned about what's happening with business. I think we're all concerned about what the trade war is how it's going to show up for businesses. And we should also be concerned about, and I'm sure all businesses are, about how it shows up for consumers at this time. We believe that we struck the right balance in this bill. And the ways we did that was to make sure that it's that the consultation is ongoing and that we would talk about how it was going to be implemented before it is through regulation. So I intend on continuing to do that work, and also by doing unprecedented things like the bill that I introduced this morning about helping businesses reduce interprovincial trade barriers so they can access more markets. In response to this, I just want to say, from those 353 responses and what we've seen in the changing of consumer protections through laws in Ontario and Alberta, there have been a lot of concerns raised by consumers, British Columbians, about how contracts show up now for them and the types of provisions that they are bound to without knowing. And it's not every business, and a lot of the small businesses that the member mentioned. I just want to say that the time before regulation and before it comes into force through regulation, it was intentional to make sure that the businesses had time to understand the new requirements and to seek out guidance from Consumer Protection BC, who's there to help people with compliance. It's not the good actors that we're targeting. It's the bad actors. It's the ones that are frauding people. It's the ones that are tying people to contracts that automatically renew in a way that causes them harm. It's making sure that we're responding better to consumers in a very complex marketplace, and it's badly needed. And the 353 responses that we received touched on a wide range of really heartbreaking stories, or stories of frustration because they were locked into things they didn't know about and paying fees that they didn't want to and couldn't get out of. So we're standing behind the work to do that, to change the protections for consumers in this complicated marketplace. So there's a whole list of things that we've addressed in this bill that come up from the consultations, whether it's online transactions, automatic renewals, gym contracts that don't allow you to cancel it even though you moved away, a whole series of things that showed up in the consultation and are showing up in people's lives every day.
Shall Clause 1 pass? All those in favor? All those opposed? So ordered. Shall Clause 2 pass? Aye. As opposed, so ordered. Show clause 3 pass. Richmond, Queensborough.
I had a chance to review Clause 3 and the proposed Section 14.21A, or 1, just 14.2, subsection 1. I'm just going to read it because I want to go through it. A supplier must not include a consumer contract, a term or acknowledgement that prohibits or has the effect of prohibiting a consumer from posting on the internet or otherwise communicating a review by the consumer of the goods or services that are subject of a contract or the consumer transaction. So I just want to get a elaboration from the Attorney General in regards to the word review.
Attorney General.
Yeah, so this is one example of the complex marketplace that we find ourselves in that's so much different than when the bill was last time it was changed, which I think was 2014. Reviews are very important right now to consumers. We all, before we purchase something, take a look at reviews online and see, you know, where should I put my money based on what the collective, almost is very democratic actually, the collective wisdom has put about the review of a certain product or good or service. And what we were seeing through consultation and some of the policy work that we did, where there were some actors that were putting in these contracts prohibitions on reviews. And you can imagine that that would not be something that I think we could all agree in this House should not be allowed. The way this provision is designed is it applies to more than just online contracts, and it applies to posting on the internet, which I think is the biggest harm, or other forms of communication. You should be free as a consumer, once you purchased a good or service, to comment on how you felt about that service to anybody, and without any restriction. So it was a clear one that we needed to change, and that's why we constructed it in a broad way.
Richmond, Queensborough.
Say I also agree with having reviews because, you know, I personally also look, just like other people, watch reviews and look at certain businesses, and when you don't have references, that's a way to kind of approach certain businesses that are new to you. So I understand that point, and but I would like to know, like, what distinguishes a genuine review from like a malicious review. There may be concerns out there that if you're prohibited from having any type of language in a clause or in a contract, that you're prohibited from prohibiting people from doing any type of review that could lead to situations such as people trying to defame you or trying to put out a malicious review, which it has nothing to do with your goods and services. So can the Attorney General explain, does this catch all types of review, or is it somehow narrowed by this legislation as well?
Attorney General.
Thank you. No, I think the member is identifying a problem in the marketplace, which is, I think you have heard from businesses that sometimes there are inaccurate or fraudulent or defamatory reviews that are put on the space. I think there's a bigger question there about the internet and how we monitor and control that I mean, we could have a deeper discussion about in terms of what the legal tool is for that. But in terms of this particular provision, it is based on giving somebody a positive right to review, right? That you have the ability, it can't be taken away from you to provide a review, which I think we can all agree is like an important part of our marketplace right now. And there would be other laws that would be triggered or be able to be used when it comes to defamatory content, like those kind of things that would tip into something that is illegal for other reasons. So there may be another legal regime there that would apply.
Richmond Queensborough.
At this time, I do note that the section seems to be good in terms of like, prohibiting, in terms of like not having certain businesses prohibiting reviews, because reviews are a good thing. But I think the section could be a lot clearer. So it could prevent bad actors and people that are not really looking to comment on the goods and services of a particular business, but they are more looking to defame or be malicious around a certain business owner. I think there could be amendment to the language here where you catch, allow all those people that need to do genuine review, allow them to do it, but the language could kind of distinguish in terms of the genuine reviews versus malicious reviews. So I'm tabling an amendment to put forward today to clause 3. And I have So,
Member, can you move the motion?
yes, I move the motion to amend Clause 3 in regards to the proposed Section 14.2. And in this amendment, in this proposed amendment, I ask if the words genuine, if the word genuine can be inserted right before review. So then the section would read, a supplier must not include a consumer contract, a term or acknowledgement that prohibits or has the effect of prohibiting a consumer from posting on the internet or otherwise communicating a genuine review by the consumer.
Thank you, member. We're going to take a short recess, and we will make copies to circulate to all the members in the House. So we'll be back shortly. All right, everybody's got a copy of the amendment. I'll call the House back to the Committee of the Whole on Bill 4 back to order. And I have determined that the amendment is in order. Richmond Queensborough.
Well, I'd like to speak to this proposed amendment. And the Attorney General has acknowledged, and we both have acknowledged that doing reviews is a good thing, and allowing reviews is a good thing. People need to know what type of products they're purchasing. I believe there's also some agreement to the fact that there may be some negative actors out there that may try to defame certain business owners or businesses, and defaming might not have anything to do with the goods and services supplied by that particular business. And the Attorney General mentioned that there may be other tools to kind of for those people to try to get at those particular businesses to use in order to, if somebody defames them. But an easier fix would probably be just to address it in this legislation by adding one word. And so it's everything's here in a compact, concise way. So by that, and it would really not change that section much at all. It would just be one descriptive word. And so I believe that would strike a fair balance for the consumers and also protect against bad actors that may target certain businesses by just adding one word. It'll make the section really easy to read and to understand and to comply with. So those are my submissions on that amendment. But I would like to reserve my time to talk about Clause 3 a little bit more after we finish talking about this particular amendment.
Yep, certainly. We're on the amendment. Thank you. Attorney General.
Okay, thank you. I can appreciate the spirit of the amendment that's being proposed, but unfortunately, I don't support it, and I'm just going to talk in detail why. I think we both acknowledged a problem of that might be happening to businesses out there where it's not a genuine or it's a fraudulent review. But there are problems with putting it in this piece of legislation and adding the word genuine. I'll just talk through them. So we start by understanding that this is a contract delivery mechanism. So it's like setting standards for how businesses have to design their contracts with consumers. And right now, it's neutral on its face. It just says you can't prohibit somebody from writing a review or telling a review on your service. And by importing the word genuine, there's a couple potential challenges with that. And first, if the government is stepping in on understanding what's genuine or not, there may be charter implications there about freedom of expression and what that means. The word genuine, I think, would be set up to be very contentious in terms of how you would, the onus could be shifted on the consumer to try to prove that their review was in fact genuine, and then the business pushing back. And I think that would actually result in probably a lot of dispute resolution and problems with that. And the other level of that is that you would need some kind of neutral arbitrator to determine what is genuine and what is not. And every time we design pieces of legislation or we design things to be clear to consumers, it's important for that clarity, right? It's important for them, and is actually a big thrust of this bill, is to have better transparency, have better clarity, make contracts simpler. And I think the word genuine and in its vagueness of understanding what that is would do, in fact, the opposite, and it would potentially create further conflict and further dispute in these contracts that might be not helpful to the ultimate goal. And I do think that I have sympathy for businesses that experience that, and there are other legal regimes that are there, but may need to be beefed up to experience or to help people with that. But I would say this is not the mechanism to do that.
Seeing no further speakers to the amendment, I'll call the question on the amendment for Clause 3 in proposed Section 4.2 to add genuine in front of review. All those in favor indicate aye. Aye. All those opposed? Nay. On division. The motion fails on division. And we're back on Clause 3, Richmond Queensborough.
Clause 3 in the proposed Section 14.3, subsection 2, and in comparison to the proposed Section 14.4, subsection 2, there's wording used, in the first example, there's wording used such as contract is void. In the second example, in the second proposed section, it says the contract is inoperative. Can the Attorney General please elaborate why there's a distinction? In one, it's referred to as void, and then the other one's referred to as inoperative.
Attorney General.
Yeah, thanks to member for pointing it out. It gives us an opportunity to explain the very intentional difference in language there. So the difference between void and inoperable. So if something's void, the result is it's intrinsically defective, meaning that even if it's agreed upon in the contract, it has no legal effect, right? And inoperable is different in the sense that there is still some remaining legal effect based on that word, and I'm just going to read out the example here. So an operative terminology would allow a claimant who commences civil litigation or joins a class action to withstand a defendant's application to stay the civil litigation or class proceeding, as long as the claim amount was at the regulation limit or below. So in the event the claimant tried to litigate above that amount, the defendant would either simply agree to litigate, or defendant would object and stay the litigation. In the stay application, the claimant would have no basis for objecting due to a deemed inoperability of a statute. So, so we're not overriding dispute resolution or arbitration permissive provisions for businesses. That's one of the reasons that inoperable is used instead of void.
Richmond Queensborough.
So both these proposed sections, 14.3 and 14.4, they talk about dispute resolution. And I take that as a reference to arbitration. And so can the Attorney General please describe the intent behind getting rid of arbitration or dispute resolution from these contracts?
Attorney General.
Yeah, so the reasons for the provisions and the amendments that we're proposing in this bill are really about how to protect the consumer in the context of arbitration clauses that would drive up costs and make resolutions hard to achieve. So the provision avoids any term in a consumer contract that requires a consumer to use private dispute resolution mechanisms or that prohibit a consumer from participating in class actions. So if it binds them to say you can only resolve your dispute this way and it bars them from being a member of a class action. But it does allow a consumer to voluntarily enter into an arbitration agreement or other dispute resolution process, but the key change is it's after a dispute has started. So if the parties, once a dispute has been triggered, decide that the arbitration is the pathway that they want to pursue to resolve it, or the CRT, which is a real benefit of this bill, because the CRT is a very low barrier part of our justice system where people can make claims for amounts under $5,000 that really help to resolve disputes. So it helps that, so it makes it an offense for a supplier to include a term that requires a consumer to use private dispute resolution process mechanisms or prohibit a consumer from participating in class actions. And one of the on the bad actor side of this, which most businesses are not, the way sometimes these clauses are used is to say, tie the person up front in a contract to extremely costly dispute resolution processes that would necessarily be higher than the value of any claim. So to frustrate any kind of remedy through that process. So these provisions prevent that.
Richmond, Queensborough.
Consumers should not be frustrated from legal remedies. But there is a point to be made here in terms of comparing arbitration and versus civil resolution tribunal versus small claims court and Supreme Court. Arbitrations, I would think arbitrations, a one-day arbitration would be a much faster process than going to, say, small claims court or Supreme Court where things don't finish in one day. It could take several days. It could take several court days and then eventually a trial date. And the thing with the civil resolution tribunal, there may not be a specialized arbitrator to look at a specialized subject matter. So those are some concerns that I have. And so in regards to that, but I just wanted to point that out. But I want to move into my next point on this clause. I want to go to the proposed section 14.4, subsection 1. There's a definition for low value claim. It refers to prescribed amount at the end. So does that mean that prescribed amount will be determined by regulation at a later time?
Attorney General.
Yes, it will be.
Richmond, Queensborough.
And then would there be, if it's going to be determined at a later time by regulation, will there be consultation done in regards to that prescribed amount or no?
Attorney General.
Yes, we're always in favor of talking to people, and as I mentioned before, we'll be doing that also in the implementation and putting in force of this bill.
Richmond, Queensborough.
Has there been any consultation done in regards to the prescribed amount currently or in the past?
recognizing the Minister of State for Trade.
Thank you, Chair. I ask leave to make an introduction.
All those in favor? Opposed? Go ahead.
All right, thank you. I would like to take this opportunity to introduce a class that is here from Scott Creek Middle School. That's you guys, right? All right. Grades 6 to 8, I believe, visiting the precinct today with teacher David Devaney. So welcome. I'm your MLA, if you didn't know, in your area. It's a new area of my riding. So welcome to Victoria. I hope you guys have a great visit. I hope to have the opportunity to see you once I'm out of here, but I'm on house duty right now. So would the House please make them feel welcome?
Attorney General.
So this is actually a design that's meant to more be an amendment that ties it to our justice system and dispute resolution processes. So I wouldn't imagine any of the public consultation we did had anybody commenting on the specific part. But what it does is it ties it into the CRT limits. We expect that would be the case, that it was 5,000 as the venue for claims that are 5,000 and more.
Shall clause 3 pass? All in favor? All opposed? On clause 3? On division on clause 3? Okay, so we'll do it again, just to be clear. So on clause 3, all those in favor, say aye. Aye. All those opposed? On division, okay. So ordered. On division. On division. And on clause 4. Shall clause 4 pass? All those in favor? Aye. All those opposed? So ordered. On clause 5, Richmond, Queensborough.
Madam Chair, I'd like to look at sections, proposed sections 18.2 as well as 18.4 in clause 5. In 18.2, the provision states a contract must include the following information: supplier's name, gets into like whether the supplier's registered, the date of contract is entered into, detailed description of goods and services, supplier's delivery arrangements, goods and services not supplied, supply date, goes on and talks about itemized purchase price, goes on, talks about including the nature of other costs, including taxes. So there seems to be a very long list here, and it just carries forward. And towards the end of 18.2 at clause T, it says, and it states any other prescribed information as well. And then on 18.4, the clause, the proposed section reads as, a consumer may cancel a contract if the contract does not include the information required under section 18.2. So in regards to this, I have a few questions. So, let's refer to some examples here. So, say for example, a supplier or a company forgets to mention their full name, forgets to write LTD after their name. Would that be in violation of section 18.4, and would that lead to cancellation of the contract?
Attorney General.
Thank you. So the question from the member prompted a deep discussion about contract law, which was interesting, but let me break it down, maybe not for most people here, but for us. So let me break it down in terms of the provisions and why they're set up this way. So most of the things that you see in 18.2 that, as the member suggested, were already in the bill. And this is one of the issues that we were fixing, is that the bill hasn't been updated since 2014. So this, instead of it showing up in random places, it's consolidated. So both sellers and buyers know exactly what the mandatory terms are for a contract. The example that the member raised was about a name being a person or a company, and that's actually potentially pretty legally significant. And I think in that example, although it's all hypothetical, you could argue that there was other contract law breaches already inherent in that example that would exist with or without these provisions. But generally speaking, this is a consolidation of things that already existed.
On clause 5, Richmond Queensborough.
So in clause 5, the proposed section 18.2 sub H talks about including taxes. But there are other acts, like for example, for the goods and services tax, there's a taxation act in regards to that says if you have a certain price, that tax should be applicable on those goods and services. So why do we have a redundant clause in this legislation right here?
Attorney General.
Just if I could ask the member, I apologize, just to repeat the section that he was referring to so we can get him an answer.
Richmond Queensborough.
We have several taxation acts, depending on which tax you're looking at. If you're looking at the GST, there's a taxation authority, a taxation legislation for that. If you're probably looking at the provincial sales tax, there's probably a taxation authority for that. These taxation legislation pieces, they talk about how tax is applicable on certain services and certain sales. So if there are those pieces of legislation out there, the question is, why are we talking about inserting tax in a particular section in this clause?
Attorney General.
Thank you for that clarification. This is not a new provision. It existed in the legislation, or existed in legislation before outside of this bill. And the reason for it is transparency for the consumer.
Richmond Queensborough.
So in terms of the last subclause, which is T, it says any other prescribed information. I understand that there's an original piece of legislation here, but I was also told that a lot of consultation happened going into this Amendment Act. So I would like to know what consultation was received and given in regards to subsection T, and what is the government thinking that is going to be included in that clause, in that subsection?
Attorney General.
So provisions like that are very common in legislation, and the reason that they're put in place like that is part of the reason why or I guess there's an example here in this bill. This bill was not updated since 2014, and the marketplace has changed a lot. So that provision T would provides flexibility, which is often put for government to respond if something does change in the marketplace that would warrant, and this is just about transparency, right? It's like you have to have these specific terms in your contract if you're contracting with consumers, and that's the reason for it.
Richmond Queensborough.
I'd just like to put it on the record that in the following proposed section 18.3, it comes up again. 18.3 subsection 1, subsection B, any other prescribed information, then it comes up again in proposed section 18.3, subsection 2, subsection C, meet any prescribed requirements. So that seems to be a common theme throughout this amendment bill. I'd like to move to the next proposed section within this clause, which is 18.4, that deals with cancellation of a contract. I'll just read that proposed section so we have it fresh in our minds. A consumer may cancel a contract if the contract does not include the information required under section 18.2. The information included in the contract is inconsistent with information disclosed to the consumer before the contract was entered into, or the supplier fails to comply with section 18.3. Going on to subsection 2 here, the consumer may cancel a contract under subsection 1 by giving notice of the cancellation to the supplier not later than the following. Subsection A, in the case of a direct sales contract or future performance contract, 1 year after the date the consumer receives a copy of the contract. Subsection B, in the case of a timeshare contract, later of 1 year after the date the consumer receives a copy of the contract. And subsection Roman numeral 2, the expiry of any longer prescribed period. Subsection C, in the case of distance sales contract, 7 days after the date the consumer receives a contract of a copy. So I just have some particular questions here. Can the Attorney General elaborate on why we have a 1 year period for being able to cancel a contract? Why do we have such a long period here of 1 year in these provisions here?
Attorney General.
Hello. So that one-year timeline has existed in the 2014, since the 2014 bill. It's always been the case. And we didn't receive any complaints or feedback about that in any of our consultation, that one-year timeline was a problem either for businesses or for consumers, so we maintained it.
Richmond Queensborough.
I would like to state that 1 year could be particularly onerous, like once somebody signs a contract and services are rendered, there might be some amounts owed for services that are just performed. And then 1 year later, somebody may just decide to cancel the contract, and you combine that with those items on the proposed section 18.2, which has a laundry list of items that you have to comply with, such as having a right date. I know there's been situations when the new year comes by and, you know, I still find myself writing 2024 instead of 2025. So just inadvertent errors such as like that, it causes alarmful thinking, just that something could be canceled with over a period of 1 year since you sign a contract with someone and you do your due diligence, but you may have just made an inadvertent mistake. So that is a bit concerning. And with that, I'd like to move another motion for amendment. I guess I can.
Okay, we're going to take a short recess and make some copies and distribute to the members, and then we'll reconvene. Okay, so copies are being distributed, and did you want to speak to the motion, Richmond Queensborough?
So as I went through proposed sections 18.2 and 18.3 and 18.4, there seems to be a common theme. There's a lot of details. And I know that explanations were provided to me, well, you know, this legislation was created in 2004. And, you know, so it was there before, some of this stuff was there before, so we're just leaving it. But isn't the whole purpose of today is to make amendment because we're trying to make this act better? And if we are trying to make this act better, if there's some mistakes from before, we shouldn't just say that they were there before, so we'll just leave them as is. So if we're trying to make things better, and there's some, there can be more clarity to this bill, Bill 4, this Business Practices and Consumer Protection Amendment Act, we should be trying to make this, this bill clear. So I've raised concerns already that, you know, there's items I spoke about dates. What if they were inadvertently, wrong date was written? I understand contract law, and if you don't put LTD and you're referring to individual or you're referring to actual company, but there's sometimes, I've seen the names of companies spelt inaccurately on court pleadings. I've seen that, but the court actually still goes ahead. So but this particular, these proposed sections or proposed section 18.2 states that, you know, the name has to be there, the date has to be there. You know, if it's plus taxes, must, PST and GST must be included, although other legislation may address that as well. And the explanation that I have received is that, well, 20 years ago, this legislation was written this way, but then the whole reason why we're standing here debating today is we're trying to make that act better. So essentially, we need to try to make it better if that is the purpose of today. So I'm proposing I've moved a proposition to make amendment to Clause 5, and I believe everybody has a copy of this. So the proposed amendment is to Clause 5, proposed section 18.4, by adding a new subsection, and the subsection would be subsection 3, so it'd be 18.4, and then once you finish with subsection 2, there'd be a subsection 3 that would read, despite subsections 1 and 2, a contract may not be cancelled if subsection A, more than 90 days has elapsed since the date the contract was entered into. I would assume 90 days would be a lot of time to review a contract if it works for everybody. And subsection B, the supplier can demonstrate substantial compliance with sections 18.2 and 18.3 subsection numeral 2, an omission or inconsistent information disclosed to the consumer before the contract was entered into did not materially affect the consumer's decision to enter into the contract. So I think this proposed amendment strikes the right balance where it shows that, you know, it gives enough time to the consumer to go over the contract and see if the contract needs to be canceled, and it also provides some protection to the supplier where they, in good faith, tried their absolute best to comply with this act. They may have made a mistake, error inadvertently, but that mistake wasn't relied upon by the consumer. So in that situation, this proposed amendment would actually protect both the consumer and the supplier, and you know, allow the contract to continue if this particular proposed section was complied with. So I honestly feel that there needs to be a proposed amendment just to address the situations, and it's not good enough by saying, oh, something was there 20 years ago, but that's the whole reason why we're here today, to make this legislation better. So that's the motion I've moved, and I hope the House can support me on that. Continue with the Clause 5. Thank you.
Attorney General.
Thank you. So I won't be supporting this amendment, and I'll just give a little background as to why. So the one-year timeline harmonizes across jurisdictions, so that's the first one. I also think there is problematic legal language in here that could be read to interpret that provision to say that a contract may not be canceled unless A and B are present. And there could be any number of reasons why a consumer might cancel a contract that are not related to the validity of the section that says what should be in a contract or not. So it could be used actually to limit the rights of a consumer to end a contract for other reasons. So I think there's wording in there that actually creates more problems. And the other reason would be that there are, I think the harm that the member's bringing forward about trying to solve is this idea of like a minor thing leading to a business or the side of that contract receiving, being out of money or out of goods as a result. And there are sections like Section 28 in the actual Act that give remedy to that in terms of returning goods that were under that contract to the business.
Going to call the question on the amendment for Clause 5 to the proposed Section 18.4 the amendment moved by the member from Richmond Queensborough. All those in favor indicate aye. Aye. Those opposed indicate nay. Nay. Okay, in my opinion, the nays have it, and it's on division. It's on division. Member from Abbotsford.
Point of
South.
order, Madam Chair. To the best of my knowledge and recollection and numbers, if you care to go review it, there were more in favor of the amendment than there were opposed.
Thank you, member. I made my decision and you have the opportunity to call division.
Then we call division.
Okay, thank you. Division has been called. Everyone online, can you please turn your cameras on? Thank you. We'll be voting on the amendment moved by the member from Richmond, Queensborough for Bill 4, Section 5, under proposed Section 18.4 to add Section 3. All those in favor, please stand, rise, or indicate. Thank you. Seated. All those opposed, please stand, rise, or indicate. Good. Thank you. Be seated. And now we'll proceed to the online voting.
Minister Bear,
I vote nay.
Minister Lohr,
I vote nay.
Emily Rochford,
I vote nay.
Mr. Clerk will announce the result.
those voting aye, Sturco, Kindy, Warbus, Banman, Cooner, Halford, Hartwell, L. Neufeld, Van Popta, Dew, Gasper, K. Neufeld, Day, Block, Bangu, Peyton, Boltby, Chan, Tour, Hepner, Giddens, Rattay, Davis, McInnes, Bird, Luck, Stamer, Moz, Tepper, Mock, Wilson, Clare, Williams, Lowen, Dollywall, Dirksen, Chapman, and McCall, 38. Those voting nay, Lohr, G. Anderson, Blatherwick, Sunner, Toporowski, B. Anderson, Neal, Osborne, Brar, Davidson, Callon, Parmar, Gibson, Bear, Chandra Herbert, Wickens, Kang, Morissette, Sandu, Krieger, Chant, La Jeunesse, Choi, Rochford, Higginson, Routledge, Popham, Dix, Sharma, Farnworth, Eby, Bailey, Begg, Green, Whiteside, Boyle, Ma, Young, Malcolmson, Chow, Glumac, Aurora, Shaw, Phillip, Deere, Valeriot, and Botterill, 47.
The amendment is defeated. And we'll now continue with discussion on Clause 5. And we'll just give it a moment for folks to clear out. Okay, we'd like to recognize, we've got some students from Scott Creek Middle School, and your MLA is the Honorable Rick Glumac there. There we go, Minister of State for Trade, and with teacher David Devani, and we've got 40 folks, 30 grades 6 to 8 here, so welcome to the Legislature. And we'll now be continuing with debate on Clause 5. Speakers to Clause 5. Okay, so shall Clause 5 pass? All those in favor say aye. Aye. Opposed, nay? Okay, so it, as so ordered, Clause 5 passes on division. Clause 6. Those opposed? Shall Clause 6 pass? All those in favor? Aye. All those opposed? Nay. So ordered. On Clause 7? Aye. Favor? Those opposed? So ordered. On Clause 8? Aye. On Clause 8? Richmond, Queensborough?
In regards to the previous clauses, previous clause 5, I was referring to the proposed sections 18.2 and 18.4 that refer to prescribed information. And similarly, in this section, I'd like to highlight in clause 8, proposed section 20.1, subsection 1, subsection J, a prescribed good or service. So there, in this clause, as it reads, a supplier must not offer for sale by direct sales contract or enter into a direct sales contract with a consumer for the supply of any of the following. So furnace, duct cleaning service, and air conditioner and air cleaner or purifier, a home security system, water heater, a water treatment device, purifier or filter, a water softener, a window or energy audit, and a prescribed good or service. So my understanding of this clause is that there have been certain bad actors in the past, and that's why the government's taking action. But what about if there are some good businesses that have been complying and they want to do some direct services? So doesn't this clause unfairly penalize them by keeping it open so they can be added onto this list? So that's my next question for the Attorney General through the Chair.
Minister.
Thank you. So this is an area that we really felt strongly that we needed to strengthen our consumer protection laws, and it is actually in line with some other jurisdictions that have similar provisions, and it's to prevent vulnerable people from taking advantage of highly persuasive sales tactics that target them at the doorstep and force sales. So it's designed in a few ways to meet that challenge. So one is it's only high-value items. So the lists you see there are not only from the consultations and our discussion with where we were seeing it through Consumer Protection BC and the ongoing times that this shows up, but also it's for things that could be $1,000 or more sold at your doorstep. What it doesn't do is tell a business to the good actor side that you can't go door to door to pitch your products. What it adds is an extra level of protection for a consumer against a high-pressure sales tactic. So if you are selling a good that is listed right now on this list, and you're going door to door talking about it, you cannot form a direct sale contract at the doorstep. There may be other ways to follow up with that person to finalize a sale, but it takes the pressure off of that transaction in that immediate person-to-person transaction, because what we are seeing is that when a highly persuasive sales persons, and a lot of them you could classify as bad actors, show up at the door to vulnerable seniors or vulnerable people that are sometimes targeted, that dynamic of the high-pressure sales environment on that individual can force them into these contracts that they don't need the good, they don't have the money, and it puts them at a real disadvantage. So we felt very strongly that this is the right balance of consumer protection against highly vulnerable people and still allowing businesses to be in contact with their consumers or potential consumers.
Richmond Queensborough.
In regards to the same proposed section, earlier we heard from the Attorney General. She referenced a letter that we were mutually talking about. It was dated March the 12th. It was a letter that was from some concerned business chamber of commerce. I'd like to just refer to the second to last page of that letter, if the Attorney General has it. I'm just going to read it. Paragraph 2. In this letter, it stated, further, the prohibition on direct sales of specified household goods and services, including furnaces, air conditioners, home security systems, and duct cleaning, raises concerns. To be clear, we strongly condemn predatory sales tactics in the strongest terms possible. We support efforts to curb unscrupulous actors. However, an outright ban on direct sales for many industries and products seems extreme. Contrary to the government's news release, many of the items listed in the legislation for the ban on direct sales are not high value services. For example, security services, when added by existing customers, can cost as little as $10 per month. This service also has personal and public safety benefits. So the Attorney General referred to high-value items sold at the doors and bad actors, but these 5 Chamber of Commerce organizations that I referred to earlier, Greater Vancouver Board of Trade, BC Chamber of Commerce, Tri-Cities Chamber, the Richmond Chamber of Commerce, Restaurants Canada, as well as the Canadian Federation of Independent Business, has put forward this letter that has this paragraph in here. They don't seem to agree with the government's perspective. What does the Attorney General have to say about that?
Minister.
Thank you. So the reason that those lists are on there was in the analysis, not only in the market, but also with our team, was that these are a list of known high-value products that are that people are vulnerable to sales at their doorstep. There are many ways that businesses can or should get products before people for sales, and a lot of times, like in the letter noted, the products are beneficial, like for public safety reasons and things like that, for home security systems. But what I will note is that in that letter, it talks about $10 a month. It doesn't talk about the value of the overall contract. So in our analysis of sometimes how these contracts show up is that it is maybe $10 a month, but it's over a long period of time. And so when the decision about whether to include them or not took the value of the overall contracts that are signed at the door, it was close to that or around that $1,000 threshold that was the value of the high-value items. It's not to say that businesses can't market their products even at the doorstep. It's that final closure of sale needs to give consumers the space of not entering that contract at the doorstep for these particular items.
Member from Richmond, Queensborough.
So the other question is in regards to consumer protection. Part of consumer protection is providing consumers with choice. So doesn't this take away from providing more choices to consumers?
Recognizing the Minister of Housing.
Thank you, Mr. Speaker. I seek leave to make an introduction.
Is leave granted?
Thank you, Mr. Speaker. We have right now in the gallery students from Scott Creek Middle School. They are here with their teacher, David Devani, and there's 40 of these students. They range from grade 6 to grade 8. They're here to watch the debate and visit the legislature. And on behalf of all of my colleagues and my colleague, the MLA from Port Moody, we want to welcome you to the legislature today. So thank you for coming.
Thank you, Minister. Minister.
Thank you. So again, it doesn't limit the choice of what a consumer would have before them, even at their doorstep. What it very directly limits is trying to put a break between the direct sale contract and the door-to-door interaction to limit to increase the protection for especially vulnerable consumers.
Shall Clause 8 pass? Aye. So ordered. Shall Clause 9 pass? Aye. So ordered. Shall Clause 10 pass? Aye. So ordered. Shall Clause 11 pass? Member from Richmond, Queensborough.
Okay, Clause 11, the proposed section here, proposed section 23, sub B, sub 5, talks about goods not being delivered within 30 days and the right to cancellation. My question is, what if there's a rogue consumer that prevents delivery of goods somehow? So will the contract still be canceled if it wasn't the fault of the supplier in terms of faulted delivery?
Minister.
Thank you. I just will direct the member to Section 53 of the Act that I think is the protection that of the instance that he's proposing that makes it so there is protections against like a consumer frustrating delivery.
Shall Clause 11 pass? So ordered. Shall Clause 12 pass? So ordered. Shall Clause 13 pass? So ordered. Shall Clause 14 pass? So ordered. Shall Clause 15 pass? So ordered. Shall Clause 16 pass? Member from Richmond, Queensborough on Clause 16.
Clause 16 refers to a proposed section 27, which speaks of refunds. And it speaks of refunds of all money. So I'll just read the clause so everybody can hear it. If a direct sales contract, future performance contract, or timeshare contract is canceled under this part, the supplier must refund to the consumer without deduction except as provided for in this part or in the regulations, all money received in respect of the contract, whether received from the consumer or from any other person within 15 days after the later of the following. The date of the notice of cancellation is given to the supplier. Next clause, subsection. If the consumer has received goods under this contract and the supplier has complied with section 28 sub 1.1, the date the goods are returned to the supplier under section 28 subsection 1. So when my concern here is maybe the Attorney General can address this. In some contractual relationships, services are provided, and say if the contract gets canceled at a later day and you got to refund all the money, so who compensates the supplier for the services that were performed if all the money gets returned?
Attorney General.
Thanks, Chair. I think we need some clarification, if the member could, on the question. Maybe we'll just wait for that. If you can give us more clarification on exactly the question, and then we'll try to answer.
Richmond Queensborough.
Well, the clause actually, or the proposed provision talks about supplier must refund the consumer all money received in respect of a contract, whether received from the consumer or from any other person, within 15 days, the later of the date of the notice of cancellation is given to the supplier, or if the consumer has received goods under the contract and the supplier has complied with the date the goods are returned to the supplier under the section. So say if it's not subsection B, but it's subsection A, notice was given of cancellation, and within 15 days of that, the contract gets canceled. But in the meantime, some services were performed. So does the supplier forego receiving remuneration for those services that were supplied before the cancellation notice was given? Like, does the supplier get anything for those services, or are they out of luck?
Attorney General.
Okay, thank you for the thank the member for the clarification. I just, so we're starting in a context of there's been a breach for some reason. So there's some kind of cause that the consumer has to give notice of cancellation that's made up in the Consumer Protection Act. So in that circumstance, the 15 days of the latter with that notification period, if there was anything in between that was done, the Act does not contemplate anything that would go to the person that was in breach of the contract.
General is stating just...
Sorry, member. Member from Richmond, Queensborough.
So the Attorney General is stating that there might be some services that might forego any sort of compensation in a brief period of time. Is that accurate?
Minister.
Yeah, thank you. It is possible that in the context of the consumer having some right to cancel a contract, so we're in a situation of a breach of some consumer protection law or maybe something else, and that happens inside or outside of this act, that the right of breach of contract may leave the contractor of that other side that's in breach out of some money.
Shall Clause 16 pass? So ordered. Shall Clause 17 pass? So ordered. Shall Clause 18 pass? So ordered. Shall Clause 19 pass? So ordered. Shall Clause 20 pass? So ordered. Shall Clause 21 pass? So ordered. Shall Clause 22 pass? So ordered. Shall Clause 23 pass? So ordered. Shall Clause 24 pass? So ordered. Shall Clause 25 pass? So ordered. Shall Clause 26? Member from Richmond, Queensborough on Clause 26.
Thank you, Chair. I have a similar question to the last one that I referred to earlier in Clause 16 in regards to refunds. So this particular proposed section is Section 50. It speaks about refund by supplier on cancellation. I'll read the section. If a distance sales contract is canceled under this part, the supplier must refund to the consumer without deduction all money received in respect of the contract and respect of any related consumer transaction, whether received from the consumer or from any other person, within 15 days after the later of the following. A, the date of the notice of cancellation is given to the supplier. B, if the consumer has received goods under the contract and the supplier has complied with Section 51, subsection 1.1, the date the goods are returned to the supplier under Section 51, subsection 1. So would the explanation for refunds, would that be similar in this proposed section as the last one that we were speaking of?
Attorney General.
Yes, the same principle would apply under these provisions.
Shall Clause 26 pass? So ordered. Shall Clause 27 pass? So ordered. Shall Clause 28 pass? So ordered. Shall Clause 29 pass? So ordered. Shall Clause 30 pass? So ordered. Shall Clause 31 pass? So ordered. Shall Clause 32 pass? So ordered. Shall Clause 33 pass? So ordered. Shall Clause 34 pass? So ordered. Shall Clause 35 pass? So ordered. Shall Clause 36 pass? So ordered. Shall Clause 37 pass? So ordered. Shall Clause 38 pass? So ordered. Shall Clause 39 pass? Member from Richmond, Queensborough on Clause 39.
Clause 39 refers to proposed section 203.001, states Division 4 of Part 2 applies to contracts entered before, on, or after coming into force of that division. So my question here, through the chair to the Attorney General, so this clause is proposing retroactivity. Is it proposing retroactivity, meaning that valid contracts that were entered into pursuant to the current state of law will be facing these new provisions under this particular section? Is that accurate to say?
Attorney General.
Thank you. So there's a nuanced qualification of the question. So it's not retroactive, it's retrospective. So what that means is it doesn't reach back in time and say that the law was always this way. It says that the law is now, as of now, into this way, and any contracts that existed before. So if you have a contract that you've entered into before the act is enforced, but it contains, and that's another important part, it's the exploitive provisions. So it's qualified by Division 4 of Part 2 that in this context, a bad actor couldn't claim that the old contract is just going to keep rolling over and be renewed and bind the consumer into that. So it gives the ability of the law to apply to those types of situations to protect the consumer.
Member from Richmond, Queensborough.
With all due respect, whether it's retroactive or retrospective, you're still trying to apply new law to older situations. And that can be problematic with business entities that have designed contracts through lawyers, have gotten proper legal advice, drafted it pursuant to the law that existed to try to comply with the statute that was there in time. And now, without much consultation, they may not know exactly what's happening here and how this stuff is being applicable to them when they were always exercised their actions in good faith and tried to comply with law. So I would say this would be quite unfair for businesses that have complied with the law as it existed, and they made the efforts to, say, consult with lawyers, have the contracts drafted properly, and now having any sort of new law applied to their situations and their valid contracts would be very unfair. So at this point, I'm moving a motion for amendment to Clause 39, and
Thank you very much, member. We're going to take a brief recess to distribute this to our members, and we will return in 5 minutes.
Distributed, not a problem.
All right, members, we'll call the committee back in order to discuss the amendment brought before the House. It has been moved, of course, and it is in order. So I would encourage the member from Richmond Queensborough to make a few comments.
I'll read the proposed amendment first. To clause 39. The proposed section 203.001 should read, Division 4 of Part 2 applies to contracts entered into, and there should be no reference to before, but it should say entered into on or after the coming into the force of this division. And why I state this is because if this doesn't happen, if this amendment doesn't happen, and the situation of having the word before there, whether you were saying it's retrospective or retroactive, it essentially comes down to the same meaning. You're trying to apply new regulation, new law to old contracts that are already existing and that were fully compliant with the law. And that type of situation creates uncertainty in the province, in business relationships, in relationships with consumers, and that's going to affect both the consumers and suppliers. Just think of the fact, how many contracts could this possibly affect? If you go with the wording that has been recommended by the government, like how many contracts would be affected? I would say in the thousands of contracts would be affected. Create a lot of uncertainty if you try to go back and apply the law, the bill as currently provided by the government. We often hear about situations where certain people are not told about certain consequences of entering certain business transactions, and later on, maybe a year later or 2 years later, that they see the consequences. They're told that they interpreted something wrongly. So that type of situation is analogous to this situation where you're now trying to propose new law and saying that it's going to apply to old contracts, so there's a new meaning to what you signed. So you didn't get what you bargained for. That's going to create a lot of uncertainty. So it would be totally unfair, and it would create a lot of uncertainty if we didn't make a proposed amendment in this situation. So we should delete the word before and make sure that the provision as recommended by the government only applies to situations on or after coming into the force of this clause as recommended by the government. So, so again, as part of my motion, as part of my amendment, I'm moving that the word before be struck and deleted from clause 39, proposed section 203.001.
Thank you, member. Minister?
Thank you, Chair. So I think herein lies a very different difference of opinion amongst us. I want to go back to Division 4 and what we're actually protecting consumers from. And one of them is contract terms that prevent them from putting reviews anywhere. The other one is contract terms that frustrate their ability to participate in a justice process of a class action proceeding. And the other one is ones that would bind them to very costly dispute resolution processes. I'm surprised by the member that he wouldn't want British Columbians to have to have the avail of those protections when this law is put into force, but I guess we just take a different perspective on that. I will make it, I just want to make it clear that it voids the specific terms of the contract, not the whole contract. And that's an important distinction. And I personally would like to see consumers in BC have that protection. And it's the reason that we're changing parts of this act to target exploitative provisions.
Thank you, Minister. Seeing no further speakers, the question before this House is the motion as proposed by the member from Richmond Queensborough to Bill 4. The question is before the House, and I would call on members that would like to pass this amendment to say aye. Aye. Those not in favor say nay. Nay. The ayes have it. Division has been called. Members, will call this committee back to order. The question before the committee this afternoon is an amendment as proposed by the member from Richmond Queensborough on Clause 39. Those in favor of the amendment, please rise or indicate. Thank you, members. Those opposed, please rise or indicate. Thank you, and now we'll turn to online. Mr. Clerk.
Minister Bear,
I vote nay.
Minister Lohr,
I vote nay.
MLA Rochford,
Vote nay.
MLA Watt,
I vote aye.
Mr. Clerk.
those voting aye, Sturco, Kindy, Warbus, Banman, Watt, Cooner, Halford, Hartwell, L. Neufeld, Van Popta, Dew, Gasper, K. Neufeld, Day, Block, Bangu, Peyton, Boltby, Chan, Tour, Hepner, Giddens, Rattay, Davis, McInnes, Bird, Luck, Stamer, Moz, Tepper, Mock, Wilson, Clare, Williams, Lowen, Dollywall, Chapman, and McCall, 38. Those voting nay, Lohr, G. Anderson, Blatherwick, Elmore, Sunner, Toporowski, B. Anderson, Neal, Osborne, Brar, Davidson, Callon, Parmar, Gibson, Bear, Chandra, Herbert, Wickens, Kang, Morissette, Sandu, Krieger, Chant, Lajeunesse, Choi, Rochford, Higginson, Routledge, Popham, Dix, Sharma, Farnworth, Eby, Bailey, Begg, Green, Whiteside, Boyle, Ma, Young, Malcolmson, Chow, Glumac, Aurora, Shaw, Phillip, Deer, Valeriot, and Botterill, 48.
The amendment is defeated.
Maybe just give it a
Members, we'll get, members, could we please get everyone into, there's still business to conduct here, members. Could we please get everyone that is not staying for committee stage to head out of the chamber? The business will continue, of course, on Bill 4. Shall Clause 39 pass? So ordered. Shall Clause 40 pass? Shall Clause, so ordered. Shall Clause 41 pass? Member from Richmond, Queensborough?
I'd like to make a motion for a new clause, just before Clause 41. So far, we've heard from the debate that like I brought forward many points, there's been about 5 chambers of commerce organizations that have said that consultation has been lacking. I pointed out many sections in this bill that there may be potential issues and in terms of consultation and in terms of interpretation. And so I'm making a motion to propose a new clause, clause 40.1.
Thank you, members, and thank you, member. We will take a very brief recess and we'll return in a few moments. Thank you, members. We'll bring this committee back to order. The amendment as proposed, or the new clause as proposed by the member from Richmond Queensborough, is in order, and I would recognize the member from Richmond Queensborough.
I'd like to first start by reading this proposed amendment. So the motion was moved to propose amendment to and add a new clause just before the last clause. The new clause would be clause 40.1, and it's in regards to having a review mechanism in this act. And I'll just read it. So it's 40.1, subsection 1. The minister, within 3 years after coming into force of sections 3, 5, 11, 13, and 14 of this act, must conduct a comprehensive review of the impact of the operation of those provisions on consumers and suppliers, with a particular focus on small businesses. Subsection 2, the minister must table a report on the review under subsection 1 in the Legislative Assembly as soon as practical. Subsection 3, the Lieutenant Governor in Council may make regulations respecting the conduct of the review under subsection 1. Now, the reason why I've put this section forward, or this proposed section forward, is the biggest point is essentially we just heard from a previous amendment that I brought forward that was struck, that was negated by the government, and that one was for to prevent retroactivity or retrospective applicable new law to old contracts. And so that was negative by the government. But this mechanism would actually allow for a review into the future to actually make sure the purpose of this amendment act is actually being carried forward. For example, the purpose is for consumer protection. We'd want to see that consumer protection is actually happening. And we want to see that the sections within the Amendment Act are actually helping consumers, protecting consumers. And at the same time, we want to make sure that businesses are not having a problem in terms of compliance, and they're able to comply to all these regulations within this legislation. So this provision allows for a mechanism for the minister to revisit the act and just to see if there's any issues, and to table a report of feedback back to the House. And if there are issues, then that can be dealt with through regulation, through the Lieutenant Governor in Council. So I don't see any harm for having a review section if the sole purpose of it is to make sure the Amendment Act will be acting as the purpose put forward by the government. So I think it can only have benefits. So I'm moving this motion to have this amendment entered into this Amendment Act.
Thank you, member. Minister?
Thank you, Chair. So I appreciate the spirit of what the member is proposing here. I do see some particular problems with the construction of the language, saying within 3 years, but also only about particular sections. The entirety of the Act is reviewed pretty regularly, not only through the actions of Consumer BC, but also our team that's out there talking to particular, and you will see in the course of this legislature mandate that there will be constant changes and reviews about the consumer protection our laws in BC. And I think it's just unnecessary regulation. We are in the context of trying to streamline processes and streamline the work that we're doing, and I think the members and opposition members agree that that's a necessary and important thing. So what I see with this amendment is unnecessary regulation and process that does nothing to help consumers in the end.
Thank you very much, Minister. Seeing no further speakers, the question before this House or this committee is the amendment as proposed to Bill 4, which is a new clause. Those in favor say aye. Aye. Those opposed say nay. The amendment is defeated. Thank you, members. We'll note that that is defeated on division. Thank you. Members, returning back to Bill 4, shall Clause 41 pass? Aye. So ordered. Shall the title pass? Aye. So ordered. Thank you, members. I'll call on the minister to move the motion.
I move that the committee rise and report the bill complete without amendment.
Members, you've heard the question. To move this report, those in favor say aye. Aye. Opposed, say nay. The motion is carried. This committee will stand adjourned.
Committee Chair.
Thank you, Mr. Speaker. The Committee on Bill 4 reports the bill complete without amendment.
When shall the bill be read a third time?
Now, Mr. Speaker.
Member, the question is third reading of Bill number 4, Individual Business Practices and Consumer Protection Amendment Act 2025. Those in favor say aye. Aye. Those who oppose, motion carried. Member, the chair already had put the question to the House. and we have taken a vote on that, so it's decided. Thank you. Yeah, no more. Yeah. Members, the bill for... Is it on? Okay, that's on. Bill for Business Practice and Consumer Protection Amendment Act 2025 has been read third time and has passed. Government House Leader.
Can we just take a short recess, please? Speaker?
The House will be in recess for 5 minutes.
Thank you, Mr. Speaker. I call the estimates for the Ministry of Agriculture.
Thank you. Committee chairs, we'll have a break for another few minutes before we start. Thank you.
Thank you.
Good afternoon, members. I call Committee of Supply, Section B, to order. We are meeting today to consider the estimates of the Ministry of Agriculture and Food. I now recognize the Minister to move the vote.
Thank you, Chair. Be it resolved this sum not exceeding $99,120,000 be granted to His Majesty to defray the expenses of the Ministry of Agriculture and Food Ministry operations to the 31st of March 2026.
Minister, do you have any opening remarks?
Thank you. Yeah, I'll just take a couple minutes here. I'm really happy to be here. I'm happy to have been returned back to the ministry where my heart belongs. We are here on the territory of the Lekwungen and the Songhees and Esquimalt First Nations to talk about, I think, one of the most important issues of the day that we have going on, considering the tariffs that are being imposed on our country and the level of awareness that the public, the consumers, Canadians, British Columbians have about food security. I'd like to welcome the opposition critic. He and I have sparred on this for many years in a row, and I look forward to the great debate that we're going to have. I'm also looking forward to welcoming new members who are going to be part of this conversation, talking about issues around agriculture and food that are coming from their own communities. We have a budget this year that has increased over $50 million since we formed government, and we're committed to strengthening BC's food system and the people who grow and produce our food. I've got a great team with me here today. I'm pleased to be supported by my ministry's executive team, which includes my Deputy Minister, Michelle Koski, and my Deputy Ministers, Eric Christensen, Paul Squires, Willow Miniker, Rambir Parmar, and the Chief Executive Officer of the Agricultural Land Commission, Kim Grout. I feel very well supported. I have a very dedicated team who shows their passion to me every day around agriculture and food, and I'd like to thank them for their public service. With that, I'm ready to roll.
I now recognize member for Delta South.
Thank you, Madam Chair. Thank you for the opportunity, Minister, to once again participate in probably my 8th agriculture estimates. You know, Minister, I would like to start by thanking you for your enthusiasm towards agriculture that we have in British Columbia, but I've heard many of your speeches with enthusiastic talk about how things are doing well in British Columbia with our farming and ranching and agricultural community. I beg to differ. I travel, as you do, throughout the province, speaking to different groups. Just last Friday night, I was up in the Black Creek, Courtenay area, chatting with over 100 farmers that came out. One thing I really enjoy about my job as Agriculture Shadow Minister for the BC Conservative Party is the opportunities to travel the province and go to many, many small towns. Every summer I go to Fort St. John, Dawson Creek, I go to Williams Lake, I go to Cranbrook, I go to the Okanagan, and there's so many parts to agriculture that are so important in this province, and we tend to think of agriculture on Vancouver Island and the Fraser Valley, but there are so many facets to agriculture when you get up north and you talk about the massive grain industry we have with canola and wheat and grass seed and bison that are being raised in the north and beef cattle. And you think of the tremendous amount of agriculture in the Okanagan and the Similkameen area with our tremendous wine growers that have faced so many hardships in the last couple of years and the fruit growers that have faced so many hardships in the last few years. And even the people in the dairy industry that are facing extremely high costs of production to produce milk nowadays. We look at the drought that we faced in British Columbia in the last few years, the extreme cold, the frost, the freezing that has wiped out our cherry population, wiped out our grape plants, etc. So there's so many things that in British Columbia regarding agriculture that we don't always just think about. You know, we think about even bees, we think about the berries, blueberries, strawberries, raspberries, all the different things that are involved in agriculture. So today, and for the next few days, I want to talk about several things that I think are not working for agriculture and for farmers and ranchers in British Columbia. Issues with the Agricultural Land Reserve, issues with the Agricultural Land Commission, the holdups, the permitting, the complaints I get constantly in my office from farmers and ranchers that are fed up with the way things are being run in this province with agriculture. So as much as there's good news coming from that side of the aisle, I find that there's a lot of negativity towards how things are being run in this province. So, Madam Chair, through you to the Minister, I think we'll start off basically talking about the budget itself. And what I'm seeing in the budget is for this fiscal year was $130 million budgeted for the Ministry of Agriculture, and for the upcoming fiscal session is $143 million. I would like to first of all ask where on page 22 of the budget booklet we see a forecast of $229 million, which from what I can see has not been added into the budget for the upcoming fiscal year for agriculture. So I would like, through you, Madam Chair, to ask what the figures actually are. Is it $143 million, or is it actually less than that because of the $229 million that were forecast to go into the budget?
Minister?
Thank you, Chair. Thanks for the question, and I know there's been some confusion over this budget this year, and I'm going to be able to clear that up for the member and this chamber. Excuse me. Budget 2025 reflects an increase of $13 million to the ministry's base budget from $130 million in 2024-25 to $143 million in 2025-26. With regard to the claim that the budget has been reduced by $100 million, this is a misunderstanding of the ministry's base budget. The discrepancy refers to a $99 million in additional claims in the fiscal year of 2024-25 under production insurance special account, which resulted in a forecast total expenditure of $229 million, $99 million over the budgeted amount of $130 million. This is money that was paid out to farmers due to extreme weather-related events, and that significantly impacted grapes and tree fruits, but it also affected the yields of forage, grain, berries, and vegetables. The increase in budget 2025-26 includes additional funds for the production insurance special account to pay the province's share of increased premiums due to commodity prices, clients buying higher coverage, and some rate increases reflecting loss experience.
Delta South.
Thank you, Madam Chair. Through you to the Minister, if we can look at the very minimal additions to the budget for the Ministry of Agriculture, we look at science, policy and inspection with a meager $99,000, $990,000 addition. Agriculture resources, $3.7 million addition. Farm Industry Review Board, FIRB, plus 16. And then, of course, we get to the Agricultural Land Commission, which surprisingly, or not surprisingly, year after year after year, does not get any sort of a decent increase to the funding. In fact, this year, the increase over last year was $55,000. And I will speak to that in a little while regarding the issues with our Agricultural Land Commission. But through you, Madam Chair, to the Minister, could you explain one more time what the total production insurance account is again, and if that includes crop insurance for our BC farmers, and if it also includes the funds for agri-stability?
Minister?
Thank you, Chair. It just includes the crop insurance and not the agri-stability.
Delta South.
Thank you, Madam Chair. Through you to the Minister. Minister, unfortunately, British Columbia is in a sad situation as far as funding for our Ministry of Agriculture. When you look at Alberta, with a population of 4.8 million people, they have a budget of $979 million for their Ministry of Agriculture. In Saskatchewan, with 1.3 million people, they have a budget of $648 million for agriculture. In Ontario, with $855 million budget for agriculture. Manitoba has a budget of over $600 million for agriculture with only a population of 1.4 million. British Columbia, with a population of 5.8 million people, has a budget of only 143 million people. Madam Chair, through you to the Minister, could you explain why British Columbia has the lowest budget per capita for agriculture of any province in Canada?
Minister?
Thank you, Madam Chair. So maybe I would just like to remind the member that since 2017, we've increased the budget for agriculture and food by $50 million. That's not insignificant, and I'm really proud of the work that we've done to get there. I remember being in opposition for 8 years and pleading with the government, the member's former government, to increase the budget for agriculture, and I was so relieved when we became government and we got it over $100 million. We're now $50 million since 2017. When we look at the baseline for the ministry's, the Minister of Agriculture's budget, there are things that are not reflected in the base budget. Those things I think the member knows very well. So agri-stability, crop insurance, and there's things that we've done outside of the base budget just in the last 2 years that if they were to be added up, there would be a significant increase overall. So we've invested $100 million in water infrastructure, $80 million in enhanced replant, and then just a week and a half ago, an announcement for $10 million for tree fruits. These sort of investments are not insignificant. Of course, it would be great to have more, but you know, there's been, I'd say, substantial support for agriculture over the last couple of years.
Delta South.
Thank you, Madam Chair. Thank you for that answer. Well, while we're on the topic of spending, as I get into budget estimates, I guess after the break, we'll be talking about the Agricultural Land Commission and the Land Reserve. And it's a dismal result of what's happening in our province with the removal of farmland, with non-farm use of truck parking, all the different things that are happening, with virtually no compliance, with only 6 compliance officers for the entire province. And we've gone over this year after year in budget estimates. So again this year, virtually no increase to our Agricultural Land Commission to be able to do the job they need to do in this province. How can you explain, through you, Madam Chair, to the Minister, again this year, virtually no increase to the funding for our Agricultural Land Commission to bring forward compliance officers to start fixing the issues in our province?
Minister?
Thank you, Chair. Appreciate the member's question, and like him, I value the work that the Agricultural Land Commission does very much. And he's right. You know, the budget has not moved up very much for the Agricultural Land Commission over the last couple years, and I think that it's an issue for them. They are trying the best with the budget that they have, and we are trying as a ministry to try and help add to from our ministry. We're trying to support them from our ministry. There's things that we do, some staff sharing, some IT support to make things more efficient. But I'm not going to argue with the member. I think that, yeah, they're doing the best they can on a budget that does challenge them.
Delta South?
Thank you, Madam Speaker, Madam Chair. I will move on to Investment Agricultural Foundation, IAF, and you've got some professional help at the table with you that was involved with IAF. I'd like to know, when it comes to money, there's millions, it's quite staggering, the millions of dollars in programs that have been handed over to IAF over the years, and yet IAF seems to be this hidden sort of, nobody ever talks about IAF, or, you know, what are they actually doing? Who's in there? Is it like a big curtain like the Wizard of Oz with somebody in behind IAF running all these programs? And they're huge. I'm just wondering, how many programs are currently running with IAF with ministry dollars? And what is the total value of the dollars of the programs that IAF are running? If you could actually list off the actual programs that are being run and the total dollars that are invested with IAF.
Minister?
Thank you, Madam Chair. So that's a great question. I actually, way back in the day, I sat on the Island Board for Investment Agriculture. And I know what the member's saying when he asks if there's a curtain or it's the Wizard of Oz, because I think years ago it really was considered the fund that nobody could access. But I think there's been so many changes in the last, I don't know, decade that has made it extremely accessible. It's very transparent. There's annual reports and et cetera that are published for public consumption. And so, you know, descriptions of board members who are, I think there's 16 made up of primary producers and food processors. There's biographies. So anything you wanted to know about investment agriculture is public. And they have delivered many of our flagship programs from the ministry. It was set up about 30 years ago for program delivery, and it has continued to be a very effective way for, as a partner for us to deliver those programs. I can get the member a full list of programs that interact with us sent to him, and he could have that information for after the break if he wants to continue on this line of questioning.
Member for Delta South.
Thank you, Minister. Thank you, Madam Chair. With IAF, I would like to know, for instance, when there's programs put in place, there's a lot of money out there for different programs, and farmers would apply to be able to make use of these funds for these different programs. But if there's, say, $20 million in a program and not all of it is used up, where does that residual money go that's left over that never got used up out of that particular program? For instance, I'll give you an example. In April 2023, the Ministry of Agriculture and Food announced $20 million for food processing fund. It's been released with 12 companies received $8.4 million, with $2.7 million going to the BC Food and Beverage Association. Where did the rest of the money go? Examples such as that. Thank you.
Minister.
Thank you, Madam Chair. So, great question. Just on the food processing fund that the member mentions, that actually was almost completely used up. So, as an example, there wouldn't really be much left there. I think it was used in whole. But in some cases, some of the program money that's put in place is not used. And what's left over will stay with investment agriculture. It'll gain interest, and then we will have a discussion as to how, whether that program is reopened again, if there hasn't been enough pickup, or perhaps there's a different priority. But that's a discussion that we would have with the board and the industry to figure out where that money will go. But it doesn't disappear, it's fully accounted for, and it's very transparent.
Member for Delta South.
Thank you, Madam Chair. Thank you to the Minister for that answer. I don't know if you recall, Minister, 1 year ago roughly was supplementary budget estimates, and surprisingly or shockingly, $111 million was dropped into the Ministry of Agriculture. No one seemed to know exactly how this money was going to get spent until roughly 48 hours later. The Minister of Agriculture at the time suddenly stood up and said, okay, here's how it's going to work. $30 million is going to the New Relationship Fund, $20 million to food security, $20 million to flood mitigation, $20 million to food processing, $20 million to innovation and affordability, and $1 million to a food hub in Richmond. Of that $111 million, can you give me any sort of progress report on this massive amount of money that 1 year ago was issued out for these 7 different initiatives?
Minister?
Thank you, Chair. So another great question, and it was a great investment to see come into the ministry, and then the priorities that were identified and where money was dispersed, I think was really helpful. That was announced 2 years ago, I believe, and since then there's been an annual report, and we also see quarterly reports coming out of Investment Ag, and it really drills down deep on where the money's been spent. So you can see how many applicants, which programs there were, where they were in the province. There's a lot of detail there, and I'm very happy to provide that to the member, and maybe he would be interested in reading it over his break.
Member for Delta South.
Thank you, Madam Chair. And I do have a lot of respect for IAF over the years with a good friend, Jack DeWitt, that's running the program right now. I'll skip back to a question I was going to ask with the budget, and I'll quickly ask that. If we look at page 69 of the budget book and under labor projections, it says that in British Columbia, we've lost 7,700 agricultural jobs. And if you could explain to us what these agricultural job losses are that have been and are forecasted for the future.
Minister?
Thank you, Madam Chair. Thanks again for the question. So those numbers come from monthly and seasonally unadjusted data from the Labor Force Survey, and it's not a reliable source for the agricultural sector for a number of reasons. Through the Labor Force Survey, though it's the source used to track year-over-year monthly employment trends at the level of the broader economy, estimating annual data for an individual sector such as agriculture using seasonally unadjusted monthly data, it's particularly problematic because it doesn't adjust for seasonality, which occurs for all industries and is particularly prevalent in agriculture. More reliable sources, such as the Census of Population and the Systems of National Account and the Agriculture and Agri-Food Labor Statistics Program, show steady trends in agricultural labor. And although we don't have the data for 2024, from those other sources, because it takes a little bit of time to get more accurate numbers, but I'd be happy to send over the the numbers from 2020 through, not till 2024 because they're not available, but happy to go and share with the member the details on the employment numbers.
Member for Delta South.
Thank you, Madam Chair. And through you, Madam Chair, to the Minister, would you be agreeable to the thought that many of our agricultural jobs having been lost recently would be from the removal of our fish farms in British Columbia that employed a lot of people, which is our biggest agricultural export in BC, farm salmon? And would you also agree we're losing a lot of jobs because of the demise of our tree fruit industry and our wine industry, where obviously if there's a demise of our tree fruit growers and wine that's being produced, that the laborers are probably leaving and going back to their homelands?
Minister.
Thank you, Madam Chair. So the member's not wrong when he talks about some of the decline in jobs available. When it comes to aquaculture, a federal decision that was made has definitely impacted the aquaculture industry. So I think that's absolutely correct. And then when it comes to the other things that the member mentioned, the wine industry, the food industry, yeah, these climate change impacts on the industry have absolutely impacted the seasonal labor numbers, because as we know, the grape die-off was very severe. You wouldn't need to be calling people back into those vineyards to tend those vines. There would be an absolute change in the type of labor that's needed. A lot of those fields and vineyards are being replanted. I actually went up to the Okanagan last year and toured through See You Later Ranch, where they had replanted a significant amount of vines. It's a different labor pool, but I think overall there's been some stabilization. So you'll see grape acreages, even apple acreages have stabilized in some ways. And so this year, we didn't go past colder than minus 20 up in the Okanagan, and I know that the member and I both believe very much that there's much more hope on the horizon for this season. The apple growers, with the influx of $10 million, have some hope for this coming harvest, and we need them to be there. The member will be just as excited as I am about the consumer enthusiasm around buying BC, and I think we're off to a good start. I'll be heading up to the Okanagan for the week next week to tour apple orchards and talk with vineyard owners and wineries, and I'm going to be able to go up there hopefully to see a little bit of bud break maybe coming through.
Member for Delta South.
Thank you. Well, that's good to hear. Thank you, Madam Chair. I'm going to move on to carbon tax, Madam Chair. The NDP forecast to raise $4 billion in carbon tax. Where is BC's agriculture sector in these numbers? There's no relief for farmers or food producers. The BC Conservatives have called for the removal of carbon tax for diesel, gas, and propane for all sectors of agriculture and transport related to agriculture. Additionally, there are calls to exempt activities essential to farm operations from carbon pricing mechanisms, activities like crop drying, CO2 enrichment in greenhouses, heating poultry farms, heating mushroom buildings, grain dryers that dry our grain up north. My question through you, Madam Chair, to the Minister, have you lobbied the Minister of Finance and other ministries to have this carbon tax removed for our agricultural sector?
Minister?
Thank you, Madam Chair. So I also have been out having conversations with farmers, and I would agree with the member that this is a topic that does come up. The BC Ag Days and the BC Cattlemen Days at the Legislature, I think this is a topic that has brought up as a topic of interest and discussion over the years. We know that there's different areas of the sector that are impacted in different ways. We did respond to the calls from the greenhouse sector, for example, to try and eliminate some of that burden for them. And a decision was made actually just as I was leaving, the last time I was Minister of Agriculture, so that they would receive an 80% discount on the carbon tax. I think the member has heard the Premier say that when the federal government eliminates the consumer portion of the carbon tax, we will follow suit. But that's one portion of it. I think that conversation needs to continue.
Member for Delta South.
Thank you, Madam Chair. Thank you, Minister. Further to carbon tax, we, as you mentioned, we have a rebate system for our greenhouses, of which I'm touring Village Farms, by the way, tomorrow morning in Delta, in my riding. Our biggest greenhouse producers are in Delta, let me tell you. Pretty impressive. But we have an 80% rebate for our greenhouse users of natural gas and carbon, of course. The greenhouse growers were happy with the change to the payment system where they're now getting their payments up front instead of a year later. So with that 80% going to our greenhouse industry, which is good, great, thank you, why can't that be provided to the rest of the people that are taxed with carbon heavily, such as our poultry industry, heating barns, people in the mushroom industry, etc., as I just said, grain dryers? Have you taken that forward to Cabinet and said, look, can we give the same 80% reduction in carbon to those other usages that use carbon every day?
Minister?
Thank you, Madam Chair. Again, a great conversation to be having with the member, and I myself hear about those concerns as well. I think cost of production and the difficulties that agriculture has faced over the last number of years is something that, you know, it keeps them awake at night. I hear it from all parts of the sector. It's just been a really difficult time. I do think that there's a bit of hope on the horizon. I know the member has mentioned in years gone by about the expenses, the cost of fuel and fertilizer being a top concern. So a tiny bit maybe of good news, a bit of good news. The two largest inputs in agricultural production fell by 14% and 20.3% respectively from 2022 to 2023. So although that's, you know, that's just one piece of it, there's a whole bunch of things, but I think that we are going after those issues, and I really appreciate the member bringing them to the forefront.
Member for Delta South.
Thank you, Madam Speaker, or Madam Chair. I want to make sure I get one question in before we break, but I'll ask one more and then I'll get to my colleague down at the end. One more question about carbon tax. The Prime Minister-elect has suggested that carbon tax will be eliminated for the consumer portion. And I believe the Premier of British Columbia has also suggested the consumer portion would also be eliminated. Would agriculture be considered as part of that consumer portion, or would agriculture in BC be considered an industrial polluter and still be charged the carbon tax?
Minister?
Thank you, Madam Chair. So, to be honest, that's not, I don't have that answer right now. That's something that's being worked on, but I would encourage the member to canvass the Minister of Finance on that issue.
Member for Delta South.
Thank you, Madam Chair. I'll turn the questioning over to, I think, one short question from the member from Prince George, North Caribou.
Recognizing the member from Prince George, North Caribou.
Thank you, Madam Chair. Through to the Minister. Currently, funding for fencing through the BC Cattlemen's Association is being directed to highway and road corridors, but not rail corridors. As you may recall, the British Columbia NDP, when in opposition, introduced a bill titled Bill M202-2008, the British Columbia Rail Corridor Safety Act, 2008. This was during the 2008 legislative session, fourth session of the 38th Parliament. This bill was intended to protect the safety and economic security of livestock owners in British Columbia whose grazing land runs adjacent to publicly owned rail corridors by placing several obligations on any railway operating on those corridors. Can the Minister indicate what work, if any, her ministry has taken regarding the outstanding issue with fencing along publicly owned railway lines like those of the BCRC, and what dialogue has the government engaged in with CN Rail and the federal government on this issue? Thank you, Madam Chair.
Minister?
Thank you, Madam Chair. So first off, I just want to say welcome to Estimates. As a new person in this chamber, it's great to have the concerns from your community being represented here. I really appreciate it. and I make this offer to anybody that wants to talk about agriculture with me, that my door is always open. If you have an issue that comes up, just come on in and we can try and figure out a solution or at least track down an answer of some sort. That's a complicated question that you asked, that the member asked this evening. If it's okay, I would like to be able to take that away over the break and then come back with the answer for the chamber, but also I'd be able to get it down on paper for the member, if that's okay.
Member for Delta South.
Thank you, Madam Chair. To wrap up carbon taxing, Madam Chair, carbon pricing is a concern, of course, for many in the agricultural sector due to its potential impact on operational costs and overall competitiveness in this province. How is the ministry addressing these concerns, and are there specific measures in place to mitigate the financial burden on farmers and ranchers, thereby ensuring the affordability of food and competitiveness in BC's agricultural products? The question is, are there incentives, Madam Chair, through you to the Minister, are there incentives that are provided by the provincial government for farmers to start converting to greener modes such as electric tractors, electric pumps, etc.?
Minister. Minister.
Thank you, Madam Chair. Thanks for the question. It's a great one, and I think it's really timely as we're heading into a future that's going to require a reduction of fossil fuels. We do have a lot of funding that's been put forward to support farmers who want to try and green up their businesses, so beneficial management practices, funding, extreme weather preparedness, so putting into place some equipment to try and fend off some of the damage from the climate change events that happen, resilient agriculture landscape programming, agriculture water infrastructure program, of course, is to address some of the issues of drought that we've been seeing, and then the tree fruit Climate Resiliency Fund. There's many categories, but to the member's point, we don't have a category for electric farm vehicles, but that's something that I think is a good program to try and work on.
I ask the Minister to move the motion.
Thank you, Madam Chair. Oh,
I ask the Minister to move the motion.
Honourable Chair, I move that the committee rise and report progress and ask leave to sit again.
Members, the question is that the committee rise, report progress, and seek leave to sit again. Those in favour indicate aye. Aye. Those opposed indicate nay. Motion is carried. Thank you, members. This committee now stands adjourned.
Committee Chair.
Mr. Speaker, Committee of Supply, Section B, reports progress on the estimates of the Ministry of Agriculture and Food and seeks leave to sit again.
When shall the committee sit again, Acting Government House Leader?
After today.
So ordered. Committee Chair.
Mr. Speaker, Committee of Supply Section A reports progress on the estimates of the Ministry of Tourism, Arts, Culture and Sport and asks leave to sit again.
When shall the committee sit again?
At the next sitting after today.
So ordered. Government House Leader.
I move the House to now adjourn.
Members, you heard the motion. All those in favor say aye. Aye. Those who oppose, motion is, I think it's passed, right? You want to go home. Motion carried. This House stands adjourned until 10 a.m. on March 31st.